When my mother passed away, my five siblings and I were disinherited, and one brother became the sole beneficiary. Like many people, my first reaction was, I'm going to sue. I was hurt. I was angry. I wanted answers. What I didn't realize was that before I could challenge anything, I first had to learn an entirely new language. The first word I had to learn was probate. Before this, I thought court was just court. I mean, I knew there was a difference between a traffic ticket and a divorce, but I had no idea that courts are divided into specialized silos. I didn't even know probate law existed. I didn't know probate court was a separate venue with its own rules, its own judges, and its own unique language. When I realized my family's dispute belonged in probate court, it gave me a place to start searching. But that's when the confusion really started. All I found were ads and articles about estate planning, why you should create a trust, what should go in it, and which lawyer to hire to draft it. That's when I realized there was a big difference between creating a trust or will and fighting one. I quickly learned estate planning because most websites, videos, and books focus exclusively on that planning phase, creating wills and trusts, and what pitfalls to avoid when setting them up. It all seems so straightforward, but I wasn't trying to create a trust. I was trying to understand how to challenge one. That's when I discovered that there is almost nothing out there for people like us, those trying to figure out what to do when something is fundamentally wrong with those documents. These are two very different conversations. Estate planning is about creating the documents, trust, wills, powers of attorney. It's before something goes wrong, side of the law. Probate litigation is different. Probate litigation begins when someone believes something did go wrong. Maybe a trust suddenly appeared. Maybe a family member was disinherited. Maybe a trustee won't provide information. Maybe someone is questioning capacity or undue influence. That's the world I found myself in. And that was the word I had been missing all along: litigation. The third word I had to learn was litigation. Litigation simply means legal disputes. This was the missing link in my search. I had spent so much time reading about estate planning, but what I actually needed to understand was probate litigation. Once I understood that distinction, things started to make more sense. I finally understood why all my searches had been leading me in the wrong direction. I wasn't trying to create a trust, I was trying to challenge one. Eventually, I filed my petition. I served my papers. I attended my hearing. I was physically sitting in probate court, and that's when I learned another word. When I was in court, I thought the court wanted to hear the evidence. I thought the discussion would be about undue influence, capacity, and everything that had happened to my family. I was wrong. Instead, the other side argued that I didn't have standing. They weren't attacking my evidence. They weren't arguing about undue influence. They weren't arguing about capacity. They were arguing that I didn't even have the legal right to be there. That's what standing means. Standing asks one fundamental question: do you have the legal right to bring the claim? In our case, we were the biological children of the decedent. If the trust was found invalid, we would inherit under California law. That gave us a stake in the outcome, but we still had to prove it. And that's why standing became one of the most important issues in our case. Because if the court had decided we lacked standing, the case would have ended before anyone ever looked at our evidence. No testimony, no documents, no trial, nothing. That's why standing is one of the first things I encourage people to evaluate before filing anything with the court. When I started this journey, I thought I needed to sue. What I actually needed was to learn the language of probate litigation. Because before you can challenge a trust, challenge a will, or challenge a trustee, you first need to understand the system you're stepping into. If you're feeling lost like I once did, I've put together a free Do I Have a Probate Case quiz. You'll find it pinned in the comment below. You'll also receive my free evidence checklist to help you organize your thoughts, your facts, and your evidence. Because before you can move forward, you need to understand where you stand.